Any appearance for the claimants?
My Lord,
Yes, please.
I am Rachel Chinyere Isofo. And
Yeah.
Rachel Chinyere Isofo.
Yes.
Appearing with me is Aja Ebili CJ, Mrs. We appear for Aja Ebili.
Spelling.
Aja, A-J-A E-B-I-L-I.
L-I.
Yes, and CJ like Chief Judge. CJ, Mrs. Yes, my Lord. We appear for the claimants.
For the claimants.
Yes, my Lord.
Sorry, ma, if I may solve, this is not our matter. Our matter is the Almighty God's power. That's between Almighty God's power and the same power. This is not our own matter.
This is
okay. My Lord.
Yes, please.
My Lord, yes, she is appearing in the matter of God's power, yes, with me. And then this matter is from Njamaze Chambers. And I am appearing in the case.
Okay, all right. Aja Ebili.
Yes,
where is this?
The defendants, are the defendants here?
Yes, my Lord, we are here.
I'm appearing with Beatrice.
See if you can.
Nchemanze.
My Lord, the defendant.
Aja Ebili, you're no longer appearing with Aja Ebili?
Yes, my Lord. My Aja Ebili will appear with me in the Yenegua case.
All right. So you're appearing with Beatrice who? Beatrice
Nchemanze.
Beatrice Nchemanze.
From Nchemanze's chambers, yes, my Lord. Right. She's online.
My Lord.
Yes, please.
My Lord, there's a mix-up. It's Beatrice Abaku.
Abaku.
Yes, my Lord. But yes, but I'm being led by my senior.
In a different matter.
Now let's clarify who appears for the claimants, please.
My Lord.
Yes.
Please, may we be clarified because we were not able to hear the suit number, so we don't know if it's our matter, my Lord.
Suit number NICNOW 42.
Oh,
that's not our own. No? That's not this one.
Okay. Yes, my Lord.
Yes, Lord. My Lord, with the greatest respect.
Yes.
Yes, L.A. in Nchemanze.
Okay.
Yes. Beatrice Abaku.
Yes, my Lord. I'm leading Beatrice Abaku, my Lord.
For the claimants?
Yes, L.A. in Nchemanze, leading Beatrice Abaku, my Lord.
Very well. I have that.
Yes, my Lord. Very much obliged for the claimants.
Right. Yes, defendants?
Yes, my Lord, we are here. My Lord,
yes,
with respect, my Lord, I am I.C. Adenno. I.C. Adenno, my Lord. A-D-I-N-N-U, my Lord.
A-D-I-N-U.
Yes, my Lord. I.C. Adenno. I'm an Assistant Chief State Counsel, Ministry of Justice, Imo State.
Right.
Yes, my Lord. My Lord, I appear with my learned friend.
Yes.
E.N. Okori. E.N. Okori.
Okori.
Yes. O-K-O-R-I-E, my Lord.
Right. Yes.
She's a state counsel in the same ministry, my Lord.
Okay.
Yes, my Lord.
Then is
right.
You can talk.
What's the key for today? Claimant?
Yes, my Lord. My Lord, this matter was commenced by way of an originating summons.
Yes.
Yes, my Lord, and we want to adopt our processes, if it pleases the Lord.
Yes.
No, the originating summons was dated the 25th day of April 2020 and filed on the 30th of April 2020.
That is if he wants to. I don't think that he wants to.
Was filed on 20th.
No, on the 30th.
30th
of April 2020.
Yes.
Yes, my Lord. My Lord, we raised various issues for determination, and our reliefs are there. We're respectfully adopting our processes in support of our claim.
Yes.
Yes, my Lord. We also filed a further affidavit dated the 2nd of February 2021 and filed on the 5th of February 2021 in response to the counter affidavit of the defendants. We've dated the, yes, filed on the 5th, 5/2/21.
Right.
Yes, my Lord. So collectively, my Lord, we're relying on these documents and urging the courts to grant our prayers.
Right. Yes, defendants?
Yes, my Lord. My Lord, first of all, we filed a PO to the suit, my Lord. That's a preliminary objection. Yes, my Lord. To this suit. My Lord, in response to their originating summons, my Lord, we filed a 17-paragraph affidavit sworn to by one Bruno Nwachukwu, a litigation officer in the Ministry of Justice.
Yes.
Yes, my Lord. Yes, my Lord, we attached 4 exhibits, Exhibit MOJ1 to Exhibit MOJ4.
Yes.
Yes, my Lord. My Lord, we also have a written address, which is dated the 14th day of July 2020 and filed on the 23rd day of July 2020.
23rd day of July
2020, yes, my Lord. Yes, we urge my Lord to dismiss this suit.
Right.
Yes, my Lord, as the appointment of the claimant was a nullity.
Right.
Yeah, my Lord, we also filed a PO to the suit.
Yes, I noted that. Yes.
Yes, my Lord.
I noted that, yes.
Yes, my Lord. It is dated the 30th day of September, my Lord, and we filed it on the 8th day of October 2020.
Is it within time?
My Lord, the preliminary objection is a preliminary objection, my Lord. It's a motion that we brought.
Processes, were they filed within time, your final written addresses?
Yes, yes. My Lord, we moved. My Lord, we had a motion for extension of time, which my Lord granted in court.
Okay.
My Lord granted it on the 18th day of March 2021.
Was
yes,
granted
on the 18th day of March 2021.
That's right.
Yes, my Lord. Yes. Thank you so much.
Right. So
my Lord,
yes.
Yes, in opposition to this application, we filed a counter.
Senior, sorry, we've not moved the PO. We are still talking about your originating process, the one I filed in opposition to it.
Right.
Yes, my Lord.
The Claimant's Counsel was going to say something. You filed a reply in opposition?
Yes, but we have filed a counter affidavit in opposition to the motion to strike out our suit, and it also has a written address attached there too.
For the affidavit?
Yes, my Lord. No, counter affidavit.
Counter affidavit. So the
yes, to the motion
to the preliminary objection.
To the PO. Right. When was it filed?
It was filed on the 5th day of February 2021.
2021, right.
Yes, my Lord. We're relying on these processes to urge the court to dismiss the objection, and we reiterate our application that originating summons be granted if it pleases the Honorable Court.
Right. Okay. Thank you, gentlemen. I wish I can screen. Let me see if let me try. Okay. The file that I'm about to deliver. I'm going to deliver judgment immediately.
As the court pleases.
As court pleases.
If I can share so that you can follow through, that will be much better for all of us.
As the
As
court
court
pleases.
Just a minute. All right, can you see it?
Yeah, yes, my lord, we can see it.
But you can you go to the next page? Is it possible for you to go down? If it's
My
possible,
lord, so sorry, my lord, our names are not on the representation page there.
don't worry. It's coming up now.
It's a bit faint, my lord, but
LC Jamaze.
LA, my lord, LA.
Sorry. LA.
Much obliged, my lord. LA.
It will come up gradually. Don't worry.
My lord, we are seeing it from here.
Don't worry, it will come up gradually. Take a while,
Okay.
but I just wanted you to follow the proceedings so I don't get bored. I'm going to read the relevant portions and then go straight to the decision. Now, these applicants, variously referred to as claimants by the parties in this suit. 20th, you can mute your mics, please. You can mute them. Well, on the 20th of December 2019, accordingly sworn in as members of the Imo State Universal Basic Education Board, that is the third respondent board, by the first respondent, referred to as the first defendant by the parties, for a tenure of 4 years. Having accepted their appointments, the Imo State House of Assembly confirmed the first applicant as the chairman, the second applicant as the secretary, the third, fourth applicants as members of the third respondent board, and they were duly sworn into office as such. However, on the 4th of February 2020, the governor, that is the first respondent, through the secretary to the state government, released a circular in which the applicants' appointments were purportedly dissolved, and they were ordered to hand over their offices and other effects to the permanent secretary of the third respondent, or the most senior public servant or chief executive. The applicants accordingly wrote a letter of protest to the first respondent on the 10th of March 2020 to no effect. Thus, the reason for this action by way of originating summons. The respondents, on the other hand, alleged that the applicants' appointments were unlawful, since at the time of their supposed appointments, their various positions were not vacant, as they were legally held by their predecessors in office, whose terms or tenure still subsisted as of 2020. To the respondents, the applicants accordingly have no sustainable cause of action before this court, and this suit must be dismissed. Additionally, the respondents raised a preliminary objection challenging the jurisdiction of this court to hear this suit on the alleged ground of it being commenced by a wrong process of court. Now, I will go straight to the decision. You'll get a copy of the document immediately after the hearing. Just a minute. Now, I have carefully considered the processes in this suit, particularly the affidavits of the applicants in support of the originating summons, the counter affidavit of the respondents, the further affidavit by the applicants, the affidavit of the respondents in support of their preliminary objection, and the applicant's reply. It is apposite, as a matter of course, that the preliminary objection of the respondents be given the foremost attention at this stage, since it attacks the jurisdiction of this court to hear and determine these suits. See Bronick Motors versus Wema Banks, etc. Now, you can also see the decision in Madukolu versus Nkem Dilim, where I cited and relied on some of the decisions there. Now, the respondents have in their preliminary objection challenged the jurisdiction of this court to hear and determine the suit, arguing that the suit of the applicants is not properly commenced by the appropriate originating process. The applicants indeed commenced the suit by originating summons, which is one of the originating processes recognized by this court. Order 3, Rule 1B of the National Industrial Court Rules 2017 states, civil proceedings that may be commenced by way of originating summons, including matters relating principally to the interpretation of any constitution, enactments, agreements, or any other instruments relating to employment, labor, industrial relations, in respect of which the court has jurisdiction by virtue of the provisions of Section 254C of the Constitution of the Federal Republic of Nigeria as amended, or by any act or law in force in Nigeria. Now, the above position of the law as enshrined in the rules of this court has already gained judicial blessings in numerous case laws. It is right, therefore, that originating summons would not be appropriate in proceedings where material facts are in dispute. However, it suffices to state that this rule of law is not a straitjacket, one that does not necessarily imply that once there is a trace of conflict or disagreement of facts in the supporting affidavit to the originating summons of the applicant and the counter affidavit of the respondent, the court must pronounce the suit incompetent. Now in Najega versus Salihu, citation supplied, Rhodes Vivor JCA, as he then was, elucidated on the inappropriate use of originating summons in the following words: where it is obvious from the state of affidavit that there will be a friction in the proceedings, then an originating summons is no longer appropriate. Now, I, however, subscribe to the submission of the learned counsel for the applicants to the extent that in deciding whether this suit is contentious or riotous, recourse must be had to the claims of the applicants and the depositions in the supporting affidavit. I also reckon that the depositions in the counter affidavit of the respondents must also be taken cognizance of in order to determine if the matter is one that can be determined purely by affidavit evidence. Now, looking at the originating summons in this suit and the supporting affidavits of the applicants, the reliefs sought are 6 in number, as previously set out above. I took considerable care in considering the above reliefs of the applicants in this suit, and it is my finding that the case of the applicants is cast on twin pillars. First is the purported dissolution of the third respondent board by the first respondent. The other is the purported removal of the applicants by the first respondent. Counsel submitted for the applicants that the applicants are challenging their removal by the dissolution of the third respondent board, and that the principal issue in this suit is the legality of the said removal of the applicants. In fact, counsel for the applicants did not mince words when he stated that the respondents clearly conceded to the fact that the first respondent dissolved the third respondent board and consequently removed the applicants from office. Now, the third respondent's body is a creation of the Imo State Universal Basic Education Law, 2005. And the same law, with no provisions on the dissolution of the board, only provides for the appointment, tenure of office of members, and the removal of members from office, among others. Suffice it to state that the first respondent cannot act in vacuum, and until so empowered, the first respondent cannot dissolve the third respondent body. Now, in suit number NICNOW 76/2006-16, Uzo Uku and 3 others by the Governor of Imo State and others, unreported, in which judgment was delivered on the 5th of July 2017 by my learned brother Anwe J on page 25. This court described the absurdity of the first respondent's act of dissolving a constitutional body in these words. Now, the first defendant went further to put an end to the existence of a constitutional body. The assertion of the defendants leaves me to wonder how the first defendant will decide to terminate the existence of the third defendant commission simply because he wants to remove a few of its members. The quotation is abridged. Now, it is axiomatic that the circumstances and scenario of the above case is similar to the ones in the instant suit. As such, this court has no difficulty whatsoever in applying the findings properly arrived at in the above case, as well as in others like Asuzu and others versus Governor of Imo, etc. Now, in fact, in the most recent decision of the court in Undubu and others versus Governor of Imo and others, unreported, this court had found, based on similar facts, arguments, and principles, that the state governor lacks the power to dissolve the state's civil service commission in the manner it did, even if the effort was merely an attempt to remove the members of the state commission only, unless and until he follows all the laid down provisions of the law or the constitution in doing so. Thus said, the first issue, I'm coming, I think I skipped something. Hold on just a bit. I skipped something. Just hold on. Yes, that did not load properly. Sorry, I have to take you back quickly because I dealt with a preliminary objection before these issues. Page 11. All right, it's loading now. Sorry, from paragraph 44. Now, looking at the originating summons in this suit supporting affidavit of the applicants, the relief source as a number, as previously set out above. I took considerable care in considering the above release of the applicants in this suit. Sorry, once more. I have it all jumbled up. That's a problem with technology.
There's a go, please.
Just a bit. I'm trying, it's supposed to synchronize. Just, right. Paragraph 45. Now, meanwhile, paragraphs 10, 11, and 16b of the respondent's counter affidavit of the respondents provide verbatim as follows. Paragraph 10 states, paragraph 5 is false. The claimants resumed duty and by February 2020 failed to discharge their duty creditably. 11, that except to deny the word purportedly, paragraph 7 of the affidavit is true, as the first defendant has dissolved the third defendant board. And 16b, that the claimants were not discharging their duty creditably and were removed on grounds of public interest. Now, in the same vein, this court has taken recourse to the further affidavit of the applicants filed on the 5th of February 2021, particularly paragraphs 8 and 9, which have been set out below. Paragraph 8 states that, and I quote, that paragraph 10 of the counter affidavit is denied to the extent that the claimants failed to discharge their duties. I and other claimants were carrying out our duties and functions creditably before the Secretary to the government of Imo State on the directives of the first defendant purportedly dissolved all boards of parastatals, commissions, and agencies in Imo State as conveyed and shown in Exhibit F, annexed to the originating summons. And 9, that there was no time whatsoever I and other claimants were queried for failure or inability to discharge our duties in the third defendant board or any other allegation, including public interest. End of quotation. Now, this court agreed entirely with the submissions of the learned counsel for the applicants that this suit calls for the interpretation of the relevant provisions of the Imo State Universal Basic Education Law, as well as the first respondent's letter of the 4th of February 2020, Exhibit F, in determining the legality of their removal. But does this finding alone qualify the suit of the applicants as one for which the use of originating summons is appropriate? My answer is in the definite affirmative. This is essentially because the respondents have not produced any scintilla of evidence to suggest that the applicants were removed from office for their failure to carry out their duties and or for public interest as alleged by them, and no document suggests that aside from that of the 4th of February 2020, the applicants were ever queried by the respondents, particularly the first, for doing anything that is likely to be considered a misconduct as provided under section 7(1) and 2 of the Imo State Universal Basic Law, 2005. Now, the facts are without doubt not riotous or hostile to necessitate the calling of evidence to resolve them contrary to what the respondents stated in their preliminary objection, as well as in their counter affidavit. In fact, not only is this case resolvable by originating summons, but it is also one that could easily and effectively have been done by way of trial on record, as provided under Order 38, Rule 33(1) of the Rules of this Court 2017, if the parties had consented to it. I can follow again. Now, moreover, there's apparently no discordance between the applicants and the respondents that the first respondents purportedly removed the applicants from their positions in the third respondent board by section 7 sub 2 of the Imo State Universal Basic Education Law 2005. The power of the first respondent to remove these applicants is not in doubt. But what is germane is that their removal must be anchored on one or more of the reasons stipulated under the said law. That is, inability to discharge the functions of their offices, whether arising from infirmity of mind or body, or for any fraudulent acts or misconducts, or in the overriding public interest. Now, the reasons for their removal by the first respondent would ordinarily have been contestable if the respondents had produced any evidence other than the letter of the 4th of February 2020 by way of exhibits to sustain what is contained in the depositions in the counter affidavit. This would have become an issue in dispute, which this court must avail parties the opportunity to call evidence, oral or otherwise, for it to resolve the dispute one way or the other. On the strength of the above premise and my reasonings, therefore, the preliminary objection of the respondents is unmeritorious and same is denied. The said application is hereby dismissed or struck out. Now, for the purpose, right. Now, for the purpose of determining the questions raised by the applicants in this originating summons, I have raised two issues thus. Whether the first respondent has the power under the Imo State Universal Basic Education Law 2005 to dissolve the third respondent board, and two, whether the applicants are entitled to the reliefs sought. Now, on the first issue, this issue calls for the interpretation of the relevant provisions of the Imo State Universal Basic Education Law 6 of 2005, along with the first letter reference, etc., of the 4th February 2020, titled The Dissolution of All Commissions and Boards of Parastatals and Agencies and its True Purpose. It is therefore imperative to reproduce the relevant sections of the Imo State Universal Basic Education Law number 6 of 2005. It's distracting.
Do you have your charger here?
Please mute your mic. It's distracting. Yes, these sections are section 6.1, which states thus: there is hereby established for the state a body known as the State Universal Basic Education Board. 2, section 7(1), which provides as follows: the chairman, secretary, and members other than members of the board shall hold office for a term of 4 years in the first instance and may be appointed for a further term of 4 years upon satisfactory performance. Please mute your mic, please.
You have not muted this mic.
Thank you. Now, section 7(2) provides thus: the chairman, secretary, or any member may at any time be removed from office by the governor for inability to discharge the functions of his office, whether arising from infirmity of mind or body, or for any fraudulent act or misconduct, or in the public interest. This court is at liberty to go into facts finding only within the context of the affidavits and evidence before it. You may see Olohunde versus Adeyeru, citation supplied. Now, I looked at the affidavit evidence of these parties before me, and I already found that there are no discordance on the fact that the first respondent, through the secretary to the government of Imo State, issued Exhibit F, a letter dated 4/2/2020, which is titled Dissolution of All Commissions and Boards of Parastatals and Agencies, and signed by one S.O. Njoku, Permanent Secretary for the Secretary to the Government of Imo State. Now, the said Exhibit F is also addressed to the third respondent board, amongst other boards. Suffice to state here that the respondents expressly admitted this fact, as can be seen in paragraph 11 of their joint counter affidavits. For clarity of the contents of Exhibit F, Exhibit F are reproduced at this juncture, and it reads as follows. I open quotation. Following government press release on the above subject, I am directed to inform all the chairmen and members of commissions, boards, parastatals, and agencies to hand over their offices as well as the administration, assets, and liability in their establishments to the permanent secretary or the most senior public servant or chief executive in the case of parastatals. Close quotation. Or rather, sorry, all handover formalities should be completed before close of work on Wednesday, 5th February 2020. All concerned are requested to be guided accordingly, please. Close quotation. Apparently, the operative parts or body of Exhibit F is not manifestly revealing an effort towards the dissolution of the third respondent as a board. This is notwithstanding the title of the said letter, which reads, Dissolution of all commissions and boards of parastatals and agencies. The law is strict in our jurisdiction that a document speaks for itself and parties are not allowed to add to or subtract from the contents of such documents by their oral depositions. In line with the above finding, I dare to reason that the true purpose of Exhibit F is actually not intended to dissolve the third respondent board, but an attempt to remove the officers and members of the same board to be replaced by new members or appointees. I quickly reiterate that this court desires an answer to the question whether the first respondent has the power to dissolve the third respondent body. The relevant provisions of the Imo State Universal Basic Education Law 2005, reproduced earlier in this judgment, are bereft of any syllable to be construed as empowering the first respondent to dissolve the third respondent board. A second look at the content of Exhibit F shows that the first respondent did not rely on any law from which it could have derived a bias to dissolve the third respondent board. The only reference on the said Exhibit F is directed at a certain press release without more. The said press release is not before the courts, and it is not the business of the court to speculate about same. The word dissolution is described as the act of bringing to an end, termination, by the Black's Law Learners Dictionary, 9th edition. There is thus no gainsaying that the first respondent cannot put the third respondent board into extinction, as any such attempt to dissolve the third respondent by the first respondent is, and until otherwise provided in any law validly enforced in Imo State, ultra vires, null and void. You may see Fashakin Foods versus Shosanya et al. Now, the third respondent body is a creation of the Imo State Universal Basic Education Law 2005, and the same law, with no provisions on the dissolution of the board, only provides for the appointments, tenure of office of members, and the removal of members from office, among others. Yes, suffice it to state that the first respondent cannot act in a vacuum, and until so empowered, the first respondent cannot dissolve the third respondent body. Thus said, the first respondent, the first issue raised for determination is resolved in favor of these applicants. Consequently and automatically, the 4 questions raised by the applicant's counsel in the originating summons are answered in their favor, as the first respondent lacks the power to dissolve the third respondent board in the manner purportedly done, and I so hold. On issue 2, issue number 1, above, already decided in favor of the applicants, equally settles reliefs 1, 2, and 3, the applicant's reliefs as contained in the originating summons. Thus, issue number 2 here should effectively deal with the reliefs numbers 4, 5, and 6 sought by these applicants. They are set out below accordingly. You'll read them. Now, learned counsel for the applicants led arguments on what he described as the perceived intention of the first respondent for issuing Exhibit F, which is letter dated 4/2/2020, titled Dissolution of All Commissions and Boards of Parastatals and Agencies. Counsel argued that the first defendant intended, in consequence, to remove the applicants from office as members of the third respondent by the said letter, which raises the question, did the said letter Exhibit F of the first respondent dated 4/2/2020 remove the applicants from office of the third respondent? The true purport of Exhibit F is invariably the case at this juncture. This court has had cause to state earlier in this judgment that the first defendant's letter Exhibit F did not purport to dissolve the third respondent body and cannot be glorified to that precinct or made to take that pride of place. Again, the content of Exhibit F reads in parts, all the chairmen and members of commissions, boards, and parastatals and agencies are to hand over their offices as well as their administration, assets, and liability in their establishments to the permanent secretary or the most senior public servant or chief executive in the case of parastatals, on the line for emphasis. Now, merely observing the language of the quoted portion of Exhibit F leaves no one in doubt that the said letter actually contemplated inter alia the removal of the applicants from the third respondent board. In other words, Exhibit F is the herald of the applicant's purported removal from office of the third respondent by the first respondent. I therefore agree with the perception of the counsel to the applicants that the first respondent intended to effectuate the removal of the applicants from office of the third respondent by use of Exhibit F. As already noted previously, the respondents neither denied the issuance of Exhibit F nor the purported effect of same, which is to remove the applicants from their individual offices of the third respondent board via that means. On the contrary, the respondents pulled up a defense of justification for issuing Exhibit F in their joint affidavit, which includes that the applicants were not validly appointed to their respective positions in the third respondent board, and therefore haven't been purportedly appointed during the pendency of the tenures of their predecessors, they illegally occupied those positions or offices. The respondents produced exhibits MOJ1, MOJ2, MOJ3, and MOJ4, which are letters of appointment of the chairman and 3 members of the third respondent dated the 17th of November 2017. It is imperative to state that the names of the said exhibits MOJ1, MOJ2, MOJ3, and MOJ4 are Honorable Lady Patience Mbakwe, Ethelbert Ibiabuchi, Barrister Sioduru, and Honorable Anthony Atudume. Apparently, these names are not parties to this suit, and it is of no moment dissipating energy, determining the circumstances of their alleged removal by the first respondent. This court shall resist the respondent's invitation to determine whether the positions of chairman and members of the third respondent board were vacant when these applicants in this suit were appointed by the first respondent. The reasons are these. First, the propriety or otherwise of the removal of these applicants' predecessors in office is neither part of the facts in issue nor relevant to the facts in issue in this suit, and cannot by any stretch of imagination assume the place of the subject matter in this suit. Secondly, the applicant's case is centered on their purported removal from office by the first respondent and the propriety of same. Thirdly, the letter of dissolution sent to these applicants does not allege that they were removed from office because their appointments were illegal, or that they were appointed when, in fact, their offices were not vacant. Fourthly, it is right that the court must limit itself to the claims before it, and as such, it is always the claimant who sets out what he is claiming. invariably meaning the case shall be determined according to his claims. You may see FATV versus Ezogo, citation supplied and others. Now, it is actually quite ironic and even amusing that the Respondents' Council relies on the defense of illegality, when in truth, the respondents, especially the Office of the First Respondent, is shown to have been used to commit the illegality of dissolving the third respondents' members as statutory appointees. It should be noted that their appointments as chairman and members of the board is not at the pleasure of the governor, in quotes, since such office is statutorily created for and entrenched within the applicable law number 6 of 2005. Now, even if it were at the governor's pleasure, their removal from office will still be subject to the provisions of that law and nothing else. You may see the cited authority. Now, the defense of illegality raised by the respondents can be likened to that of a man who stole his neighbor's chicken, cooked it, and ate it with the same neighbor's children, only to argue later in defense that the same neighbor benefited from his illegality since his children also ate from the stolen chicken. Therefore, it is tried beyond citing of authorities that the aim of the court is to do substantial justice between the parties, and any technicality that raises its ugly head must be rebuffed by the courts. You may see the cited authority. The first respondent cannot, while violating the law, still be allowed to benefit from same. Now, it is also tried that the courts are bound to enforce the mandatory provisions of the substantive law. It is the duty of all courts to give effect to legislation. Parties cannot, by consent or acquiescence or failure to object, nullify the effect of a statute or constitution. Furthermore, it is the duty of the court to enforce mandatory provisions of an enactment. You may see Adedeji versus National Bank of Nigeria and others, citations supplied. As such, it is necessary to understand that the framers of the law never intended for the executive arm of the government to act whimsically with respect to the appointments, tenure, and removal of the members of the third respondent board. Otherwise, it would have left the aspect of the removal of these claimants stroke applicants silent. Now, the only manner in which these applicants could have been removed from office, therefore, is as expressly provided under Section 7.2 of the Imo State Universal Basic Education Law 2005. Not having exhibited any evidence of compliance with the provisions of the above section of the law, the Office of the First Respondent indeed disregarded the provisions of the extant law for the removal of the applicants from office. The Office of the First Respondent actually left so much to be desired when it offended the spirit of Section 7.2 of the Imo State Universal Basic Education Law number 6, 2005, when he afforded no reason whatsoever for the purported removal of the applicants from the office of the third respondent board. Having thus found that the applicants were legitimately appointed by the first respondent in 2019 and subsequently sworn in based on uncontroverted evidence before this court, the defense relied upon by these respondents as have been stated earlier in his judgment, become utterly weak and incapable of outweighing the applicant's evidence. Following the decision in Nundubu and others versus Governor of Imo State and others, Supra, this court has placed the evidence of both parties on an imaginary scale and finds it more probable and reasonable to believe the applicant's affidavit evidence that they had assumed office in accordance with the provisions of the Imo State Universal Basic Education Law 2005 and operated the affairs of the third respondent from the 3rd of June 2019 until the 4th of February 2020, 7 months only before their illegal removal. These applicants' tenures should ordinarily come to an end in 2023, ceteris paribus. As such, having been forced out of office illegally, the applicants become entitled to their salaries and allowances for the unexpired months which they had left at the time of their illegal removal. Sichi Gozieze and others versus Governor of Abia State and others, citation supplied. Now, the alternative, of course, is a reinstatement to their positions, which they hitherto held, for them to serve out their terms and their tenures in accordance with the provisions of the Imo State Universal Basic Education Law 2005. even though this court acknowledges that the applicants have not sought for any reinstatement order. Either way, the applicants are, for all intents and purposes, not yet legally removed from office. Based therefore on the above findings, this court is satisfied that the applicant's case succeeds, having those answered all the questions raised in this originating summons in their favor, I hereby enter judgment for the applicants and grant all the 6 reliefs sought by them. Judgment is entered accordingly.
As the court pleases. Very much obliged, my lord.
Thank you. Sorry for the intermittent mix-ups.
Most obliged, my lord.
Thank you.
Yes, my lord. My lord, I still plead that where you have the representation.
Yes, don't worry, it will change. Don't worry about that. Trust me, you'll get
okay, my lord. Thank you so much, my lord.
You will see a change. Now you have IC Adinu. And
yes, my lord. Yes, my lord. My lord, if my lord it would be so kind enough. One of us that is very sick just walked into the office. And I called her earlier that she should join us. Her name is C.A. Sunday Ihero, my lord. She has always been coming for the matter with me. C for Cameroon. C.A. Sunday hyphen, my lord, Ihero, I-H-E-R-U-E, my lord.
Sunday Ihero.
Yes, my lord. 3 of us, we've always been coming for this matter.
I-H-E-R-U-E.
Yes, my lord. Thank you so much, my lord. We appreciate so much.
You're welcome.
She's a principal state council.
Thank you. I allowed you to read through with me.
Yes, my lord.
A novel invention. I hope it
yes, my lord. Yes, my lord. We so much appreciate for being part of this Zoom setting.
But just in case it doesn't stick, that's a ground of appeal for you. It will be boring. It will be very boring if you are just listening to me and you are not following.
Yes, my lord.
Yes, my lord, but we followed, my lord. We followed it.
I really appreciate your presence as well. You'll get a copy, a signed copy.
Yes, my lord.
Copy of this judgment, hopefully by the end of today.
As the court pleases.
Thank you.
So much obliged.
Most obliged.
Can we have the next case?
Yes, my lord. My lord, number 2.
Yes.
NICN/OW/44/2020 between 1, Right Honorable Jonas Onwebuchulam Okeke, and the 3 others, and 1, Governor of Imo State, and 3 others. That's it, my lord.
Oh. Yes, Atira.
With the greatest respect, my lord, L.A. Njemanze.
Right.
Well, my learned friend, B.A. Abaku, Miss, appears with me for the claimants.
Yes. B.A. Abaku.
Yes, my lord.
Right. Okay. Yes, defendants. Are the defendants here?
It's the same representation, my lord.
Same representation?
There was a different, no, there was not. There was another, yes. It was a House of Assembly.
The defendants are absent then.
It's MC.
No, we are not. My lord. Sorry, my lord. Yes. My lord, one of us in the Ministry of Justice is handling this case. So I called him yesterday to inform him about this. I don't know. I'm so surprised he did not hook up, my lord.
Okay. So
yes, my lord.
Are you going to appear for them?
Yes. No, my lord, I don't mind, my lord.
All right. So defendants absent.
Yes, my lord. But my lord, since that's in the same ministry, they can't ignore the proceedings.
Their portfolios. They all have their portfolios.
As the court pleases.
Maybe they have their own. They have their own rules, regulations, how matters should be handled.
As the court pleases.
And then absence, not represented, rather.
But aware, he was notified, my lord.
Okay. So counsel claimant, yes.
Yes, much obliged, my lord. This is another originating summons, my lord.
Yes.
And we're prepared to proceed.
Yes.
The originating summons is dated the 25th of April 2020. And we filed it on the 30th of April 2020, my lord.
It was filed on April 20th.
The 30th, 30.
April, yes.
Yes, my lord. 2020, yes, my lord.
Yes.
My lord, we're seeking various, we've raised various questions for determination and issues. I beg your pardon. Okay, yes. We have various questions for determination. There are 4 of them, and we have 6 reliefs we're claiming. We have an affidavit in support. We have a written address with various exhibits, my lord, and we respectfully adopt these processes in urging my lord to grant our originating summons.
Right.
Yes, my lord. My lord, the respondents filed a counter affidavit.
Yes.
On the 4th of August, 2020.
Fourth of August 2020.
Yes, my lord. They also have a written address attached there too.
Yes.
My lord, in response to that, we filed a further affidavit on the 5th of February, 5/2/2021.
Yes.
Yes, my lord. We're respectfully urging that all these documents be taken into consideration in determining this matter and granting reliefs.
Yeah.
Very much obliged, my lord.
Right. Now, the defendant's counsel was aware.
Yes, my lord.
Court clerk, was he served?
Yes, my lord. He was notified.
He was notified. And then I remember Miss Adino also said
she spoke with him yesterday.
Yeah.
Yes, my lord.
Right. Now, okay. So I actually have a judgment. Let's see how far we can take it.
As the court pleases.
Right. I'll try and see if I can share it as well.
As the court pleases.
Right. This is Okeke, I believe.
Yes, Lord.
Right. Can you see it on your screen?
Yes, Lord.
Right. Now, in the same vein, I'll just go through the more important issues since you get the copy of the judgment immediately to save time.
As the court pleases.
These applicants, variously referred to as claimants by the parties in this suit, were on the 20th of December 2019, accordingly sworn in as members of the Imo State Local Government Service Commission. That is the third respondent by the first respondent, referred to as the first defendant by the parties, for a tenure of 4 years. Having accepted their appointments, the Imo State House of Assembly confirmed the first applicant as the chairman and the second, third, and fourth applicants variously as various members of the third respondent commission, and they were duly sworn into office as such. However, on the 4th of February 2020, the governor, as the first respondent, through the secretary to the state government, released a circular in which the applicants were purportedly dissolved, and they were accordingly ordered to hand over their respective offices and other effects to the permanent secretary of the third respondent, or the most senior public servant or chief executive. The applicants collectively wrote a letter of protest to the first respondent on the 10th of March 2020 to no avail. Thus, the reason for this action by way of originating summons. The respondents, on the other hand, alleged that the applicants' appointments were unlawful, since at the time of their purported appointments, their various positions were not vacant, as they were legally held by their predecessors in office, whose terms or tenure still subsisted as of 2019. To the respondents, the applicants accordingly have no sustainable cause of action before this court, and the suit must thus be dismissed. That is the summary. Now let's go straight to the decision. Let's hold on. Let's see how. The documents need to refresh sometimes.
Yes, my Lord.
Otherwise, you won't get the current version. Right. I have carefully examined the process and given deep consideration to the issues and questions elicited by either counsel. This court shall, however, adopt issue 1 of the applicant's written address and the sole issue raised in the respondent's written address for the judgment of this court. These are the centric issues for determination, whereas other questions raised are mere strata of the said main issues, which shall accordingly be determined in the course of making my findings. Now, for ease of emphasis, the said 2 main issues are reproduced hereunder. 1, whether the first defendant has the power under the Imo State House of Assembly law to dissolve the third defendant's applicant's issue number 1, and 2, whether from affidavit evidence before me, these applicants deserve the reliefs they seek from this court. Respondents issue 2. Issue number 2, well, only issue. Right, it wouldn't mark there. Anyway, on issue 1, on issue number 1, this issue calls for the interpretation of the relevant provisions of the Imo State House of Assembly law, along with the first respondent's letter reference by SGI, etc., of the 4th of February 2020, titled Dissolution of All Commissions and Boards of Parastatals and Agencies, and its true purport. We highlighted 3 sections. Section 3, sub 1, it provides as follows. There is established in Imo State a House of Assembly Commission. Section 5, sub 1, a member of the commission shall hold office for a period of 5 years from the date of his appointment, and he may be reappointed for another term of 5 years and no more. Section 10, sub 1, provides a member, including the chairman of the commission, shall be removed from the office by the governor acting upon an address supported by 2/3 majority of the members of the House of Assembly, praying that he be removed for inability to discharge the functions of his office, whether arising from infirmity of mind or body or any other cause or misconduct. Now, this court is at liberty to go into facts finding within the context of the pleadings. And for clarity of emphasis, they are both subject members of commissions and over their offices. Now, I wish to
The battery. Let's go inside and plug it in.
Okay.
Bring it. Let's go. Let's move well down. Plug it in.
I think we had a break in transmission.
Not that one, not that one. No.
I don't know whether it's NEPA this time around or something else. Are we back? Are we reconnected?
Yes, my lord. It's
Are we
been breaking
reconnected?
up.
Yes,
Yeah,
my
What
lord.
disrupted? Yes, I get. Right.
Yes, my lord, yeah.
Sorry about that. Is the screen still sharing? Can you still see the screen?
Yes, my lord. We can see, my lord.
All right, good. Now, I wish to reiterate as a guide that the current issue seeks answers to the question whether the first respondent has the power to dissolve the third respondent. The relevant provisions of the Imo State House of Assembly law reproduced earlier in this judgment are bereft of any syllabi or syllable to be construed as empowering the first respondent to dissolve the third respondent. A second look at the content of Exhibit E shows that the first respondent did not state any law from which it could have derived the bias to dissolve the third respondent. Now, paragraph 33. Now, thus said, 33 is 32 here. It is axiomatic that the circumstances and scenario of the above case is like the ones in the instant suit. As such, this court has no difficulty whatsoever in applying the findings properly arrived at in the above cases, as well as others like Asuzu and others versus Governor of Imo State and others, suit number NICN OW 20/2014, unreported. Thus said, the first issue raised for determination is resolved in favor of these applicants. Consequently, the 4 questions raised by the applicants cancelling the originating summons are all answered in their favor. as the first respondent lacks the power to dissolve the third respondent commission, and I so hold. Now, on the second issue, let me go straight to paragraph 36. You get the copy, please. Now, it is imperative to state that the alleged predecessors in office in the third respondent commission are not before this court, and it is a dissipation of energy determining the circumstances of the alleged removal by the first respondent. This court shall thus resist the respondent's subtle invitation of this court to determine whether the offices of the chairman and members of the third respondents were vacant when these applicants were appointed by the first respondent. The reasons are, first, the propriety or otherwise of the removal of these applicants' predecessors in office is not the subject matter of this suit. Secondly, the applicant's case is centered on their purported removal from office by the first respondent and the propriety of same. Thirdly, the letter of dissolution sent to these applicants does not allege that they were removed from office because their appointments were illegal or that they were appointed when in fact their offices were not vacant. And fourthly, it is trite that the court must limit itself to the claims before it. And as such, it is always the claimant who sets out what he is claiming, invariably meaning the case shall be determined according to his claims. Now, the only manner in which these applicants could have been removed from office, therefore, is as expressly provided under Section 10, Sub 1 of the Imo State House of Assembly law. Not having exhibited any address supported by at least two-thirds majority of the Imo State House of Assembly, the office of the first respondent indeed disregarded the provisions of the extant law for the removal of the applicants from office. The office of the first respondent actually left so much to be desired when it offended the principles of separation of power by usurping the legislative functions of the Imo State House of Assembly in the purported removal of the applicants. Having thus found that the applicants were legitimately appointed by the first respondent, confirmed by a resolution of the House of Assembly of Imo State, and subsequently sworn in based on uncontroverted evidence before the court, the only defense relied upon by these respondents is that the immediate past chairman and other members of the third respondent did not exhaust their tenures at the time when the applicants were appointed and assumed office, becomes weak and incapable of outweighing the applicant's evidence. Following my earlier decision in Unjuku and others versus Governor of Imo State and others, Supra, this court has placed the affidavit evidence of both parties on an imaginary scale and finds it more probable and reasonable to believe the applicant's claims that they had assumed office in accordance with the provisions of the Imo State House of Assembly law and operated the affairs of the third respondent commission from the 20th of December 2019 until the 4th of February 2020, 3 months only before their illegal removal. The applicant's tenure should come to an end in 2024, ceteris paribus. As such, having been forced out of office illegally, the applicants become entitled to their salaries and allowances for the unexpired months which they had left at the time of their illegal removal. The alternative, of course, is a reinstatement to their positions which they hitherto held, for them to serve out their terms and tenures in accordance with the provisions of the Imo State House of Assembly law, even though this court acknowledges that the applicants have not sought for any reinstatement order. Either way, the applicants, for all intents and purposes, are not yet legally removed from office. Based, therefore, on the above findings, this court is satisfied that the applicant's case succeeds. Having thus answered all the questions raised in the originating summons in their favor, I hereby enter judgment and grant all the 6 reliefs sought by them. Judgment is entered accordingly.
My Lord, we're very grateful. We're much obliged, my Lord.
Thank you. Again, you'll get a copy, a CTC copy of this judgment immediately after proceedings, hopefully today.
As God pleases.
Is the Respondents' Council now here? All right. Please call the third case.
Yes, my lord. Suit number NICN/YEN/27/2017 between Amade God
Hold
Power
on, Jamaze, do you still have
and
another
person.
case? Hold on.
No, my lord. May we be excused?
Okay, you may. I thought there were 3 matters.
Oh, it is true we were given notice of, my lord.
Oh, it's all right. So we have
We were given notice of 2.
okay, it's all right. That's okay. Maybe you can take another day.
Very
for the
much
third.
obliged.
Right, you're welcome.
Thank you very much.
Yes, please.
Yes,
NICN
NICN/YEN/27/2017 between Amade God Power and Ferguson Manpower Supply Limited. That's it, my lord.
Ferguson Manpower.
Yes, my lord.
Yes. Parties, are they here? Are the parties?
Yes, my lord.
Yes. Yes. Virtual procedure.
My lord, yes, I am Rachel Chinyere Nsofo. And appearing with me is Aja Ebili CJ Missy. We appear for the claimants.
The name again, Ajayi Bili.
Aja Ebili.
Yes.
AJAEBILI.
Yes.
CJ.
Yes.
Missy.
For the claimants.
We appear for the claimants, yes, my lord.
Right. Defendants.
Defendant is in court, and my name is Prince. My name is Prince H.O. Egelemai for the defendant.
Prince.
Prince H.O. initials.
H.O.
Egelemai.
Egelemai.
Oh, yes, sir.
Spelling, please.
Yes, sir.
Spelling.
Egelemai is spelled E-G-I.
Yes.
E-L-E-M-A.
Egelema.
I.
M-A-I. Egelemai.
M-A.
Okay. Hold on.
Yes, sir.
Hold on. Let me refresh something. Yes. Claimants, what's the case for today?
Yes, my lord, it's for adoption. And yes, my offer the final addresses by the claimant.
Okay.
And my learned friend, Ajay Bili CJ, will do the adoption,
Right.
my lord.
Ajay Bili?
Yes, my lord.
You have, how many matters do you have today? You have
My lord,
sister
it's
matters.
just, oh yes, we have up to 13 claimants.
We have 13 separate suits.
Yes,
No, my lord.
yes. Though we consolidated them, my lord.
Yes, sir. Hello. 212.
They were consolidated for the purpose of
Trial.
Yes, my lord.
the sake of the trial.
Yes, my lord.
Now, they judge to be 13 separate judgments. Your final written address will be 13 separate final addresses for each of them.
Yes, my lord.
And the judgment will be 13 judgments.
My
Yes.
Lord, the matter has been completed. My lord, that one final address.
Yes?
Yes, sir.
I can't hear you very well. Can you speak up?
The matter has been consolidated. So the trial, the matters were jointly tried. So the written addresses be written for the 13 claimants. One. There is no separate written address for each claimant. This matter is now consolidated.
Okay, so
Lord,
it's consolidated.
My Lord,
Yes, please.
the matter was consolidated upon hearing, but you in your writing, you said upon judgment that you will separate it.
Yes.
Oh.
That's what you said in your writing, that the matter is consolidated upon hearing, but at the
Because
time of judgment, it will be separated.
Yes.
My Lord, it's not. My Lord, in law, it's not possible. You cannot separate. Yes, sir.
Yes.
My Lord, it's Joy that talk, the registrar.
The issue is this, because you have different amounts.
Claims.
Yes.
Monetary claims.
Yes.
But the scenario is one and the same in each of the matters.
Yes, my Lord.
So when making an enrolled order, it has to be separate. Unless you are saying that you just want one trial today and then you continue with other trials separately. Egelamai.
So that was not what was done. They called a witness which testified on behalf of the 13 claimants. It was a joint trial.
So are you saying that the money, the entire monetary?
Yes, but their claims are different. They are not asking for the same amount. They're actually asking for different claims. Or what led to the suit was a particular issue, but they're asking for different claims. That's what my Lord is trying to. If I got my Lord,
find out from you before we go into anything. Let us resolve this issue now.
Yes.
Because
yes,
I remember saying that when you're making the judgment, you have 13 different.
My Lord, that is what is in your record, my Lord. My Lord, your record states the matter is consolidated for hearings for trial's sake. When at the time of judgment, it will be separate. That is what is in your record, my Lord.
And we are also aware of that. Yes, my Lord. That's what we have.
Now, defendants, are you with us?
I'm with yes, sir. I'm with you, sir.
I have you on record as saying that the case was consolidated, so all the claims, all the monetary claims were lumped up.
Exactly, sir. Yes.
You have an idea of how much the lumped monetary claims are?
And on the date of constitution, we were in court after the matter has been called, so I do not have an idea.
That's why I said it's safer to separate each of them rather than lumping all claims, because each file has separate amounts, monetary claims. I think it's only fair to allow each of the matters be done separately, particularly now. But the reliefs sought are the same in all the matters, is it not? So the claimant's statement of facts is the same. The defendant's statement of defense is the same. Is that not so? So that we will separate each of them when making the enrolled order. You have 13 different judgments instead of one. Then you can still, you can still use that for whatever purpose you need to. Now the case was consolidated, so all the monetary claims for all the 13 cases were lumped up. And then I said, we separated. Now we separated the cases for the purpose of having 13 separate judgments at the conclusion of hearing. So claimants, defendant, did you file, you want to adopt or did you file anything?
File a written address, my Lord, we're prepared to adopt.
All right. We filed the final written address when?
Well, the registrar had the copies of all my written addresses, and she didn't tell us. But I know I can continue from the material I have here.
You didn't get a copy of the claimant's final written address. Is that what you're saying?
Yes, no, I did not get it.
Is that true? Can you confirm that, court clerk?
No, my lord.
You are not served with claimant's final written address since 2020.
My lord, we served. I'm very certain we served.
Are you saying that
qualified? They were served, my lord.
Is the case ripe for adoption?
Yes, my lord.
Defendant, is the case ripe for adoption?
Yes, my lord, it is right for adoption.
I think the defendant has actually gone off. Defendants, Mr. Gelamai, are you there?
I think he's off. He's
Yes,
off,
I
my
think his
lord.
network. Let's wait for him to come on.
Yes, my lord.
My lord, probably his data has finished.
Okay, try calling him. We'll wait for him.
He did not buy enough data, my lord.
Is he back online? I believe
No,
so.
my lord. Maybe he went to go and buy data.
Mr. Gelamai, are you back online?
Yeah, I'm back online, sir. I'm back online. Sorry.
Now we have him
Back
back
online.
All right, we waited for you to come
Yes,
back.
sir. We're having issues here. Yes, sir.
So now, what do you want? Is the case ripe for adoption? Are you ready for adoption?
My lord, yeah, my lord, we want to adopt so that we'll get this matter done with for adoption, sir.
Okay.
I'm ready for adoption, sir. Yes, sir.
All right. So let me hear you adopt yours.
Yes, sir. My lord, before I move to adopt my written address, I want to draw the attention of the court to one of the exhibits we tendered during trial. It is the writ of, my lord, one of our defense we raised was that this same matter is being tried in a sister court in Port Harcourt. Am I is it called following, sir?
Yes.
Sir. One of the defenses we raised.
Yes.
One of the defenses we raised was that this same trial, this same party's claimant is sued in a similar court in Port Harcourt. That there's an abuse of court process. That is one of the defenses we raised. My lord, during trial we we already got. Yeah, we tendered a writ of summons. Yes, but in the process of tendering the original copy of the writ of summons, we did not accompany it with the statement of claim, which embodied the number of claimants, 55 claimants. We did not accompany it with the writ of summons, which we tendered in court. But we front-loaded. Yes, sir. My lord, I have the other copy, the statement of claim, which we have, which we out of inadvertence we could not tender. Yes, sir. The list of claimants is written on the statement of claim of the matter of the someone we tendered before the court. Yes, sir. There are 55 claimants who sued before the court in Port Harcourt.
The one before the court yesterday.
Mute your mics. Mute your mics. You are not in the proceedings. Yes.
But what we are saying is that the claimants in this present case are included among the claimants that have a matter, this same matter in the court in Port Harcourt, that this is an abuse of court process. I'm just drawing your mind to the name of parties in this case, which are also present in the case in Port Harcourt.
Yes.
That the statement of claim, we did not present the statement of claim.
This same document is one that should have been brought during trial, not at this stage.
My Lord, my Lord, we know the court. The court can adopt the rule that is convenient and where justice will be met. It was inadvertent that we only brought the surface copy of the writ of summons. We did not. We could not accompany it with
the fact that
the statement of claim.
The fact that someone exists does not mean that it could not have been brought, but you can't bring it now at this stage.
My Lord, my Lord, we know that, sir, but we know this, the court. We know the court. The court is out to do justice. The court can bypass the rules to apply what the court thinks is we make the course of justice fly. Yes, sir.
Right.
My Lord, we uploaded it. We uploaded it before the court. We uploaded the full matter before the court. Yes, sir. We uploaded the full writ of summons, the entire case before the court.
Well,
just that when we were attending the original, the statement of claim was not included. Yes, sir.
Well, I've already noted that the evidence cannot just be brought at this stage of the proceeding. But you have asked me to do what is fair and I've taken note of that. Okay.
Yes, sir. My Lord, the court is out to do justice. That's what we believe the court will do, my Lord.
All right.
Yes,
evidence has already been closed, but I will do what is fair and just.
As God pleases. As God pleases. My Lord, we filed a written deposition at the close of trial, my Lord. We filed a written deposition at the close of trial.
Yes.
My Lord, we hereby adopt our address, our argument in this case.
When was it filed?
My Lord, I told the court that the processes are at the registry and we were not served. But I can't have the date to file, but it should be in the file, my Lord. I'm very sorry, sir.
Was duly filed? No, you
yes,
wish
sir,
to
it was
adopt?
duly filed, sir. Yes, sir. I wish to adopt our written statement, yes, sir, as our argument in this case.
And urge the court to dismiss the case?
As court in its entirety, for lack of merit, my Lord. Yes, sir.
Right. Yes.
Yes, sir.
Any more? Any more?
No, but that's all for us, sir. That's all for the defendant, my Lord.
All right. Clemens?
Yes, my Lord. In response to the defendant's final written address, we also filed our final written address is dated the 23rd day of October, 2020.
Yes.
And filed on the 28th day of October, 2020. Yes, filed 28th.
Was it within time?
Raised 3 issues. Yes,
Was
my Lord, it was. Wherein we raised 3 issues and we canvassed arguments to that effect. We humbly urge my Lord to resolve these issues in favor of the claimants and grant all our relief. May it please, my Lord.
All right. Okay, I think I already have a judgment prepared. I can deliver. I'll go ahead and deliver it immediately.
Okay, my Lord.
Because we've already wasted so much time. So I'm going to see if I can share. Let's see. Let's see if I can share it. Like I can.
Recording in progress. Recording in progress. Recording in progress.
The other time talking here, you hear you. Okay, just one day. The showing again.
Yes, we just yes, we just
I'm not sure I have it. I'm not so sure if it can reflect. Okay. All right. Just wait. All right. I don't know if you can see.
You can see it, my lord.
Right. Okay, judgment. The claimant was recruited as a driller by the defendant company, and he was duly issued a letter of offer of employment / conditions of service, which he signed in acceptance of the offer with effect from the 17th of November 2012. Pursuant to a contractual agreement earlier executed between the defendant and Niger Blossom Drilling Company Limited, the claimant was sent to work in rig NB 102 at the Pan Ocean oil field in Ologbo, Edo State of Nigeria. However, the contract between the defendant and Niger Blossom Drilling Company Limited was terminated consequent upon the termination of the contract between Niger Blossom Drilling Company Limited and Pan Ocean. It transpired that at the time of the said termination, the claimant was owed a total of 3,427,000 naira only, representing his unpaid salaries and entitlements. After several futile attempts to get his money, the claimant has now resorted to this suit. The defendant, on the other hand, alleged that the claimant cannot maintain this suit against it, since it only acted as an agent of the claimant in the entire transaction and no more. Defendants state that Niger Blossom Drilling Company Limited, a third party, was the employer of the claimant, and the latter, but not the defendant, should be sued for the entitlement supposedly owed the claimant. The defendant urged this court to dismiss this suit for being an abuse of court process for the sole reason that the contract between the claimant and it, that's the defendant, is unenforceable. Now, the claimant's complaint was duly filed on the 20th of February 2017, wherein he seeks one relief. The total sum of 3.427 million naira only, being and representing the claimant's outstanding and unpaid salaries and benefits for the period of his employment contract with the defendant. Now, upon the receipts of the complaint and the accompanying processes, the defendant filed a memorandum of appearance, a statement of defense, and other accompanying processes on the 24th of October 2018. Issues were joined at the end of pleadings, and during trial, the claimant called the lone witness and tendered 3 documents in all. At the close of the case of the claimant, the defendant also called 1 witness and tendered 4 documents accordingly. Now, at the end of the trial, the defendant's counsel filed his final written address and submissions and arguments on the 29th of September 2020, and the claimant's counsel filed his own final written address and submissions on the 28th of October 2020. Now, on the 24th day of June 2021, that's today, the parties' counsel adopted their respective arguments and submissions, whereupon this court immediately pronounced and delivered these judgments. Now, the case of the claimant, as gleaned from his pleadings, is that he was employed by the defendant as a driller on the 17th of February 2012, and the terms and conditions of service is as contained in a letter of employment, which is Exhibit C1A, titled Offer of Contract of Employment stroke Conditions of Service, with effect from the 17th of February 2012. Now, sequel to the said employment, the claimant was posted by the defendants to work with the defendant's clients, that's the Niger Blossom Drilling Company Limited, at rig NB102 at the Pan Ocean Oil Field in Ologbo, Edo State, where the claimant accordingly worked until May 2013, when his employment was terminated by the defendant company. Now, according to the claimant, at the date of the said termination, the defendant owed a total sum of 3,427,000 naira only, which sum was arrived at as follows. A, outstanding salaries for the months of March to May 2013, which stood at 1.950 naira. 2, 2012 Christmas bonus, which was 325,000 naira. Annual safety award, 32,000 naira. 2012 annual leave allowance, 325,000 naira. End of service redundancy, 2012, 312,000 naira. End of service redundancy, 2010 prorated, 104,000 naira. Repatriation, 60,000 naira. Ex gratia, 160,000 naira. And termination stroke resignation, 156,000 naira. According to the case of the claimant, a petition dated the 19th of October 2016, signed by one Mr. Joseph Kayode Oluwadamisi, in a representative capacity on behalf of the claimant and other affected persons, stroke staff of the company, was sent to the zonal coordinator South-South of the National Human Rights Commission for redress. And upon the advice of the State Commission, the claimants petitioned the zonal director South-South of the Federal Ministry of Labor and Employment via a letter dated the 31st of October 2016, signed by the same Mr. Joseph Kayode on behalf of the claimant and other affected staff of the defendant for redress. It is the case of the claimant that the defendant admitted owing him, but sought for time to defray the said indebtedness, but failed to do so to date. In all, the claimant tendered 3 documents in evidence in this suit. These are: 1, letter of employment dated 17/2/2012, Exhibit C1A. 2, letter to the National Human Rights Commission dated the 19th of October 2016, Exhibit C1B. And 3, letter to Ministry of Labor dated the 31st of October 2016, Exhibit C1C. Now, CW1 testified on the 13th of June 2018, and he was cross-examined on the 31st of October 2019 by the defendant's counsel, whereupon the claimant closed his case. In its defense, stated that following an advertisement for qualified drilling personnel, it, being a labor supply company, recruited the claimant and others on behalf of Niger Blossom Drilling Company Limited. The defendant accordingly negotiated the terms of the employment of the claimant and thereafter reduced the said terms into writing. The defendant directly received the salaries and other entitlements of the claimants and remitted same to him. And in respect of any complaint by the claimant regarding his conditions of service, the defendant would always act as an intermediary between the claimant and Niger Blossom Drilling Company Limited. Against this backdrop, the defendants posited that it only acted as an agent in the said employment contract between the claimant and the Niger Blossom Drilling Company Limited. Accordingly, because of this arrangement, the defendant issued Exhibit C1A to the claimant, but that Niger Blossom Drilling Company Limited remained the employer of the claimant. Now, it is also the case of the defendants that the claimant was issued a personnel on board document, which supposedly defined the employment relationship between the claimant and Niger Blossom Drilling Company Limited as one of employer and an employee, which documents the defendant gave the claimant a notice to produce at the hearing of the suit. According to the defendant, therefore, the relationship between the claimant and Niger Blossom Drilling Company Limited continued until 8 April 2013, when one Ben Osimili, a night pusher engaged by Niger Blossom Drilling Company Limited, caused a severe damage to the rig, consequently resulting in the sudden termination of the contract of Niger Blossom Drilling Company Limited by Pan Ocean. The defendant stated the fact that there was arbitration between the defendant and Niger Blossom Drilling Company Limited in respect of the unpaid entitlements owed the claimant and other staff, in which Niger Blossom Drilling Company Limited agreed with the defendant to settle the claimant and other affected employees. However, Niger Blossom Drilling Company Limited accordingly failed to honor these agreements to date, observing that Niger Blossom Drilling Company Limited had failed to settle the claimant and others as agreed. The defendant, with the authorization of the claimant and others involved, instituted a civil action, suit number NICN/YEN/444/2016, Exhibit D2, for the recovery of the salaries of the claimant and other 54 staff from Niger Blossom Drilling Company Limited, which suit is still pending at the Port Harcourt division of this court. Now, in all, the defendant tendered 4 documents in evidence in this suit. They are: 1, labor contract dated the 30th of December 2011, Exhibit D1. 2, a writ of summons in suit number NICN/YEN/444/2016, Exhibit D2. 3, demand notice from defendants dated the 28th of June of 2013, Exhibit D3. And 4, demand notice from defendant solicitor dated the 10th of June 2016, Exhibit D4. And the defendant's case opened on the 20th of March 2020, and his witness testified and was cross-examined the same day, whereupon the defense closed his case. This court thereafter ordered the parties' counsel to file their written addresses and submissions within the apportionable number of days in accordance with the rules of this court. Now, counsel to the defendant filed his final written submission on the 29th of September 2020, albeit out of time. In it, he admitted 3 issues for determination by this honorable court as follows. 1, whether considering the circumstances of the contractual relationship with the claimant, the defendant, and Niger Blossom, and the specific roles played by the parties in this transaction, the defendant can be held to be the employer or an agent of the claimant. 2, whether this action is not an abuse of court process. 3, whether the contractual relationship between claimant and defendant is legal and enforceable. Now, on issue number 1, counsel submitted that the claimant did not prove that the defendant was his employer. Counsel stated that the defendant debunked the claim that the defendant was the employer of the claimant by stating that the defendant's business, as the company's name suggests, is purely recruitment. Counsel maintained that the claimant tendered his offer of employment letter without more and has not proved his case based on a balance of probability. Counsel recounted the defendant's intermediary roles to the claimant and the Niger Blossom Drilling Company Limited, and submitted that at the termination of the claimant's employment, the defendant went on to negotiate with Niger Blossom Drilling Company Limited on the claimant's outstanding salary and other benefits, and even instituted a civil action on behalf of the claimant and other affected staff. Council canvassed that by virtue of the roles played by each party in the transaction, the relationship between the claimant and the defendant is aptly one of principal and agent by implication and by conduct. It stated that the defendant's evidence, where it stated that it informed the zonal director, South Federal Ministry of Labor and Employment, and in the presence of the claimant, that the defendant is claiming the claimant's entitlements before the court. Now, relying on the strength of the decision in UTC, PLC versus Phillips, etc., counsel submitted that by failure to object when the said revelation was made before the zonal director, South Federal Ministry of Labor and Employment, the claimant had ratified the position of the defendant as his agent, and to that effect, the claimant should be stopped from claiming otherwise. Highlighting Articles 1, 12, and 17 of the labor contractual agreement between the defendant and Niger Blossom Drilling Company, counsel argued that the literal interpretation of the said provisions is to the effect that Niger Blossom Drilling Company has the obligation to provide the funds for the payment of the claimant's salaries and other entitlements, while the defendant undertakes the administrative burden and management of the employees. Against this backdrop, counsel submitted that the defendants therefore issued the employment letters to the claimant in the defendant's name. Relying on the authorities in Ihama versus SPDC citations supplied and others, defendants counsel urged this court to confine itself to the plain word and meanings derivable from the provisions of the contract documents of the parties, and hold that the defendant was an agent of the claimant and not his employer. Now, learned counsel to the defendant further urged this court to presume that the personnel on board, which the claimant did not produce after due notice to produce was issued to the claimant by the defendant, would, if produced, be unfavorable to the claimant, as it would have been clear by the said document that Niger Blossom Drilling Company actually employed the claimants. Reliance was placed on Section 167D of the Evidence Act 2011 and the decision of this court in the case of Audley versus State, citation supplied. Now, on the defendant's issue number 2, learned counsel submitted that this suit constitutes an abuse of court process for the reason that same was instituted after the claimant became aware that the defendant had already instituted an action on behalf of the claimant and other 54 affected staff against Niger Blossom Drilling on the termination of their contracts and their respective salaries and other entitlements. Counsel argued that the defendant obtained the consent of the claimant and other 54 employees before instituting the said action on their behalf, and only the claimant and some 12 others out of the 55 affected employees instituted separate actions against the defendants. Reliance was placed on the authorities of United Cement Company of Nigeria Limited versus Itita, citation supplied, and other cases, while counsel stated circumstances that could constitute an abuse of court process in relation to this current suit, and urged this court to dismiss this suit as being abusive and for being instituted in bad faith. On the defendant's issue number 3, counsel to the defendant submitted succinctly that this action by the claimant is an attempt to enforce an illegal contract. Counsel canvassed further that the claimant and the defendant engaged in a contract in contravention of the provisions of Section 23 of the Nigerian Labour Act. Hence, such being illegal, no party should be allowed to benefit from it. He cited in support the corporate Ideal Insurance Limited versus Ajakuta Steel Corporate Limited citation supplied. Now, claimant's counsel submissions and arguments. Claimant's counsel filed a written submission dated the 23rd of October 2020, was filed on the 28th of October 2020. In the said written submission of counsel, 3 issues were nominated for determination by this court. These are set out as follows. 1, whether from the provisions of Exhibit C1A to C1C and the circumstances of this case, the defendant can be said to be the employer of this claimant, whether this claimant this claimant's action as presently constituted can be said to be an abuse of judicial process, and C, whether a party can be allowed to benefit from his own illegality. Now, on the claimant's issue number 1, counsel drew the attention of this court to the contents of Exhibit C1A, referred to by counsel as Exhibit A, and particularly paragraph 1 of the said Exhibit A, which counsel quoted as follows. I open quotation. We are pleased to inform you that we have been offered a contract of employment with Fedicine Manpower Supply Limited with effect, etc., etc., close quotation. Counsel further argued that it was the defendant who placed an advert for the employment to which the claimant subscribed, and after putting the claimant through some interviews, the defendant issued to him a letter of employment signifying a contract between the claimant and the defendant. Relying on the authority of Afrotech Technical Services versus Meyer and Sons Limited, citation supplied, and other matters and other cases, counsel urged this court to adopt and consider the ordinary and plain meanings of words constituted in the said Exhibit A, and not to allow any imputation or subtraction to be made thereto. Now, quoting from clause 3.4, tenure/stroke amendment of Exhibit C1A, which provides that the offer of employment and condition shall only be for the period within which the company needs the services of the claimant, and that the term of the contract is inviolable. Counsel urged or argued that the defendant made and issued the said Exhibit C1A to the claimant, and nowhere in the said document is it provided that the defendant did all that on behalf of any third party. Counsel submitted that the contention by the defendant that the said employment of the claimant was carried out by it for a third party is an afterthought. Learned counsel vehemently disagreed with the contention by the defendant that Exhibit D1, which is labor contract agreement, was executed for the benefit of the claimant as an employee of Niger Blossom Drilling Company Limited. He stated that Exhibit D1 made on the 30th of December 2011 between the defendant and Niger Blossom Drilling Company Limited cannot be for the claimant who was recruited in 2012. Accordingly, it is right that the claimant who is not a party to the said contract in Exhibit D1 cannot enforce same, even if it was made for his benefit. Can cite any of these matters cases here. Now, Learned Claimants Counsel argued that on the said Exhibit D1 relied on by the defendants provides in Article 12 that the defendant shall be recognized as the employer of the claimant and other staff who are all supplied to serve in Niger Blossom Drilling Company Limited. As such, that section expressly conferred upon the defendant the responsibility of an employer to the claimant. Also, that when CW1 was asked for the cross-examination by counsel, if the agreement he was giving was a tripartite agreement, the witness answered in the negative. In respect to the personnel on board card allegedly containing the relationship between the claimant and Niger Blossom Drilling Company Limited, and the implication of the claimant not producing same even after the notice to produce was given by the defendant, counsel submitted that the burden is on the defendant to prove how the said personnel on board shows the relationship between the claimant and Niger Blossom Drilling Company Limited. On this argument, counsel cited the authority of Akimbodi versus Babatunde and other citations supplied. Counsel finally submitted on this issue that the said personnel on board card cannot be said to define the relationship between the defendant and the claimant, even in the light of the provisions of paragraphs 4, 5, and 6 of the DW1 statement on oath, which states that Exhibits C1A and D1 are the documents that provide the terms and conditions of service of the claimant. More so, counsel submitted that there is no evidence adduced by the defendant to the effect that the said personnel on board card actually defined a relationship between the defendant and Niger Blossom Drilling Company Limited. Counsel urged this court to discountenance and the submission by the defendant's counsel on the said card as such legal argument cannot take evidence, place of evidence. Now, on the claimant's issue number 2, counsel submitted that it's erroneous for the defendant to contend that this suit constitutes an abuse of court process on the alleged basis that the claimant has the knowledge of suit number NICN YEN 444/2016 Exhibit D2 instituted by the defendant on behalf of the claimant and other staff against Niger Blossom Drilling Company Limited with the authorization of the claimant. Claimant's counsel relied on the authority of Abubakar versus Bebeji Oil and Allied Product Company Product Limited and other citations supplied on the definition of the concept of abuse of judicial process. On the elements that will constitute an abuse of court process, counsel relied on the case of ACB versus Nwego. He urged that this contention by the defendant amounts to an afterthought since the DW1 stated on the cross-examination that the claimant did not give express authorization, but that the claimant was in a meeting where the commencement of the said action was discussed. Then the counsel was discussed to discountenance this contention by the defendant as lacking in merit, as the name of the claimant is not mentioned as a party in the said suit number NICN/YEN/444/2016 for this suit to constitute an abuse of court process. Now, on claimant's issue number 3, counsel argued that the same defendant company that had argued vehemently that it was not the employer of the claimant is now asking the court to hold that the contract between the claimant and the defendant is illegal for being in contravention of Section 23 of the Labor Act, as the defendant had not procured the employer's permits required under the said law. Learned counsel submitted that a defendant should not be allowed to benefit from his own wrong and called in aid the following and local cases or authorities. Finally, learned counsel submitted that the defendant failed to state the particulars of the alleged illegality in its pleadings. And such failure is fatal to the case of the defendants when, as in this case, it is only raised for the first time in the counsel's final written address. Now, counsel relies strongly on the case of WCC versus Batala and urge citation supplied and urges court to discountenance the submissions of the defendant on this issue. He urges court to enter judgment on behalf of the claimant and grant the reliefs sought in the interest of justice. Now, I have carefully gone through the entire processes, evidence, and the written submissions of counsel for both sides. This court is convinced that the issues raised by learned counsel to these parties are substantially identical and essential to the just determination of this suit. So with a little modification, this court thus considers the 3 issues raised by both parties in the following sequence. 1, whether in consideration of suit number NICN YEN 444/2016 between Credit Manpower Supply Limited versus Niger Blossom Drilling Company Limited, this current suit by the claimant does not constitute an abuse of court process, issue number 1. And 2, whether the contractual relationship between the claimant and the defendant is legal and enforceable, that's issue number 2. And 3, whether considering the transactions between the claimant and the defendant and Niger Blossom Drilling Company Limited, the defendant cannot be held to be the employer of the claimant, issue number 3. Now, it is primal on issue number 1 to consider this first. This is the decision arrived here will determine the fate of the other 2 issues. Importantly, this issue questions the jurisdiction of this court to hear and determine the suit. Now, the defendant contended in paragraphs 10 and 11 of DW1's deposition on oath that this suit constitutes an abuse of court process and that the said contention is hinged on the alleged fact that the defendant had instituted suit number NICN/YEN/444/2016 Exhibit D to the knowledge of the claimant and on his behalf against one Niger Blossom Drilling Company Limited. Under cross-examination, when asked to show evidence of how letter or document authorizing the defendant to institute the said action on behalf of the claimant, DW stated that the consent was given in a meeting when the claimant also attended, and his name was written in the minutes of the same meeting, which document is kept in the office of the defendant. Exhibit D2 indeed reveals that this defendant, as claimant, instituted a suit on the 30th of November 2016 for itself and on behalf of the personnel it provided for Niger Blossom Drilling Company Limited, the defendant therein. Now, upon closer inspection, it is clear that Fedicine Manpower Supply Limited, this defendant claims the following monetary reliefs. One, the sum of 72,512,000 naira, 12,015 naira only as special damages being and representing outstanding salaries, allowances, bonuses, payoffs, commissions, and other entitlements due to the claimants and the personnel workers hired by the defendants from the claimant in pursuant to their collective agreement dated the 30th day of December 2011, and two, the sum of 10 million naira being general damages for breach of contract. From the above contents in Exhibit D2, the defendant in this suit appears to seek to enforce its contractual rights against Niger Blossom Drilling Company Limited by virtue of the said collective agreement dated the 30th of November 2011, Exhibit D1, in a separate suit. Now, this court, however, has taken cognizance of the name of this present claimant as contained in paragraph 5 of the statement of facts in Exhibit D2, listed among 54 other personnel of the defendants on whose behalf the defendant allegedly instituted suit number NICN YEN/444/2016. It is imperative at this juncture to reproduce paragraph 6 of the statement of facts in Exhibit D2, which provides that 6. The claimant avers that it is the agreement between the two companies that for all categories of personnel supplied by the claimant to the defendants, wages shall be paid by the claimant monthly, and the defendant shall provide to the claimant the funds for employees' salaries. That to this effect, invoices shall be submitted by the claimant to the defendant's Human Resources Development or Department for payment. Now, from the facts and circumstances of this suit in relation to the issue number 1 under consideration, this court has found that there exists a chain of contractual relations between the parties in this suit. Now, by this I mean that while the defendant seeks to enforce its rights in the contract between it and Niger Blossom Drilling Company Limited via suit number NICN YEN/444/2016 Exhibit D2. On the other hand, the claimant is by this suit seeking to enforce his rights in a separate contract between him and the defendant herein as contained in Exhibit C1A. Now, going further, this court has also taken cognizance of the fact that there exists another separate contract between Niger Blossom Drilling Company Limited and Pan Ocean, which contract was later terminated. Now, though the latter contract is not before this court and is not the subject of the current suit, however, both parties in this suit captured this fact in their various pleadings. There is no gainsaying that though all the parties stated above are involved in the same transaction, the various contracting parties are distinctly bound by the terms of their respective contracts, and each can enforce his rights under his own contracts. The claimant and the defendant have a separate contract, Exhibit C1A, which is the gravamen of this current suit. Obviously, this claimant, like any other person, has the constitutional right to approach this court for the determination of the existence or extent of his civil rights or obligation arising from Exhibit C1A. See Section 6(6)(b) of the Constitution of the Federal Republic of Nigeria as amended. Now, for the avoidance of doubt, I find that the parties in suit number NICN YEN/444/2016 And these current suits are not the same parties, or more so, the subject matters are separate and distinct, so that the determination of the suit cannot render nugatory the outcome of suit number NICN YEN 444/2016 and vice versa. Tersely put, issue 1 must be resolved in favor of the claimant against the defendant. I therefore find that this suit does not amount to an abuse of court process in view of the pendency of suit number NICN YEN 444/2016, and I so hold. Now, on issue number 2, this issue 2 is not unlike issue 1 above, and still deserves consideration as it equally questions the jurisdiction of this court to hear and determine this for the supposed reason that the contract which the claimant seeks to enforce by this suit is illegal and unenforceable. I shall consider the arguments bordering on this issue as submitted by the respective counsel for the parties. The defendants raised this issue for the first time in the counsel's final written address, and this has miffed the claimant's counsel, who urged this court to discountenance it on the basis that the question of illegality was never specifically pleaded or particularized in the pleadings filed by the defendants. This court indeed found that truly those facts alleging illegality were never pleaded by the defendant. More so, there is no evidence adduced by the defendant or elicited in support of this issue anywhere. This notwithstanding, this court shall consider this question because it is a jurisdictional one hinged on grounds of law, which can even be raised for the very first time at the Supreme Court. Now, the defendant's counsel hinged his legal arguments on the allegation that the defendant did not procure the employer's permit as required by Section 23 of the Nigerian Labour Act, and that this suit should be dismissed on that basis. Now, it is imperative to take a vivid look at the provisions of Section 23 of the Labour Act, which states as follows: subject to this section and Section 48 of this Act, no person or association shall recruit any citizen for employment as an employer or as a worker in Nigeria or elsewhere, except in pursuance of an employer's permit or recruiter's license. Now, the above provision of Section 23(1) of the Labour Act is clear and unequivocal. The section provides for a statutory compliance directly binding on every employer or recruiter in Nigeria to seek or to first seek and obtain an employer's permit or recruiter's license, as the case may be, before going into any employment or recruitment businesses in Nigeria. Now, counsel to the defendant argued that the defendant did not obtain the said permit or license before employing the claimant. To my mind, this fact as alleged by the defendant has not been substantiated in any way. In other words, there is no evidence to support the allegation. Hence, the want of evidence to support this issue is inarguably detrimental to the party who raised it. The question is now on whom lies the burden of proof in this circumstance. On this, it is tried that whoever wants the court to believe in the existence of any fact and give judgment to that effect must prove that such facts exist. See Section 131 of the Evidence Act 2011. Now, more so, the fact in contention in this issue is one specifically, within the knowledge of the defendant or its counsel. And I have no hesitation finding that the defendant has the burden of proving the alleged facts that the defendant did not obtain the necessary permit or license before the recruitment or employment in Exhibit C1A. The argument by the defendant's counsel in this issue is impotent and cannot convince this court. It is even ludicrous that the defendant could find the scruples to raise this issue in the first place. Even if there was genuine evidence to support this issue, it will not have assisted the defendant in destroying the case of the claimant. As a matter of fact, a contract has been held to be illegal where A, the consideration of promise involves doing something illegal or contrary to public policy. B, the intention of the parties is to promote something illegal or contrary to public policy. C, the terms and conditions are expressly prohibited by or contrary to the provisions of a law or statute. See the case of Onyuike, the third versus Okeke citation supplied, and another. Now, the contract between the claimant and the defendant as contained in Exhibit C1A is certainly not within the ambit of the above conditions, and I cannot hold otherwise. The parties cannot be said to be in pari delicto, that is, in mutual agreement to engage in any illegality. The defendant's counsel argued that the said failure to produce or procure a permit by the defendant is a crime. But what the learned counsel is not saying is that the said crime is one solely against the defendant, which the appropriate law enforcement agency or institution should investigate and take appropriate action thereto. The duty to procure the said permit lies on the defendant, and in the ordinary course of business, an employee would not investigate whether his employer has complied with the said requirement. Thus, the presumption of regularity would always inure in favor of an employee in a situation like this. It is my observation that there are no syllables in the said section 23 of the Nigerian Labour Act 1974 to be construed as rendering Exhibit C1A illegal or unenforceable, and I so hold. As such, I hereby resolve this second issue again in favor of the claimant. Now, both counsel are by this issue on the third issue inviting this court to decide whether the defendant can be properly regarded as the employer of the claimant. I made recourse to the pleadings of the parties, evidence adduced, importantly exhibits C1A and D1, and submissions by both counsel. Exhibit C1A is an offer letter from the defendant titled Offer of Contract, Employment / Condition of Service, and signed by Chief Mrs. Millie Okpoko, Managing Director for Fedicine Manpower Supply Limited. The said Exhibit C1A was duly signed in acceptance of the offer by the claimant hearing. One of the major, on the other hand, rather, Exhibit D1 is dated December 2011, titled Labor Contractual Agreement between Niger Blossom Drilling Nigeria Limited and Fedicine Manpower Supply Limited, and duly signed by Kashmir C. Maduafokwa for the Niger Blossom and Chief Mrs. Millie Okpoko for Fedicine Manpower Supply. Apparently, as can be deduced from these two documents, Exhibits C1A and D1, Exhibit C1A above all is a document of employment, clearly evidencing the basic elements of a valid contract of employment, that is, offer, acceptance, and consideration. In the same vein, Exhibit D1 is undoubtedly a documentation of the extent of an agreement between the defendant and Niger Blossom Drilling Company Limited. It is noteworthy that the defendant has, by its pleadings and legal submissions, invited this court to look beyond the contents of Exhibits C1A and D1 to consider the conduct of the parties, that is, the claimant, defendant, and Niger Drilling Company Limited. Now, this court shall consider the current issue under the purview of the evidence adduced on both sides and in line with the circumstances of this suit. The introductory paragraph of Exhibit C1A merits a reproduction at this juncture, and it provides as follows, and I quote, "We are pleased to inform you that you have been offered a contract employment with Fedicine Manpower Supply Limited with effect from 17 February 2012, underlined for emphasis." Now, also the succeeding paragraph 3.6 of the same Exhibit C1A instructively states as follows, and I quote, "This contract is subject to review every year during the contractual period. The review does not call for meeting between employee and employer," underlined for emphasis. Some paragraphs in Exhibit D1 have caught the attention of this court, and amongst them are Articles 12 and 27. These paragraphs are reproduced as follows. Article 12, that is the employer labor contractor's obligation. I quote, "Labor contractor shall be recognized as the employer of the persons which are provided to the company underlined for emphasis. Now, it is instructive that the word employer has been used copiously in the above excerpts from Exhibit C1A and D1 to qualify and characterize the defendant in this suit. But the defendant has consistently argued that the defendant is only an agent of the claimant, while Niger Blossom Drilling Company Limited is the claimant's employer. The defendant has in one breath relied on the decision in Hammer versus SPDC, citation supplied to urge this court to confine itself to the plain and ordinary meanings of words used in the provisions containing the rights and obligations of the parties to this suit, but in another breath asked the court to look beyond the plain contractual obligations to pronounce that it merely acted as an agent of the claimant with a third party. I, however, agree with this that this court should confine itself to the plain and ordinary meaning in the contracts documents of the parties in this suit. This is fortified by the position of the law that a contract of a purely master-servant relationship, as in this case, is governed by the mutual and exclusive agreement between the contracted parties and nothing more. This is the essence of the maxim pacta sunt servanda, which means agreements must be kept. Without further ado, this court finds it difficult to agree with the defendant's counsel's submission to the effect that an interpretation based on the plain and ordinary meaning of the words used in Exhibits C1A and D1 actually suggests a relationship of principal and agent between the claimant and the defendant. This court thus finds that the nature of the relationship between the claimant, the defendant, and Niger Blossom Drilling Company Limited is to the effect that the defendant, a manpower supply company, excuse me, employed the claimant as well as other skilled workers in different categories and hired them out to Niger Blossom Drilling Company Limited in accordance with the provisions of Exhibit D1, which was executed by the defendant and Niger Blossom Drilling Company Limited. In essence, the defendant is the direct employer of the claimant and not Niger Blossom Drilling Company Limited, as the defendant's counsel would want this court to believe. The master and servant contract between the claimant and the defendant is sacrosanct and clothed with majestic immutability, and this court cannot rewrite it to suit the defendant or anyone for that matter. Furthermore, counsel to the defendant made a heavy weight of a certain personnel on board document averred to be contained in, and averred to contain the true relationship between the claimant and Niger Blossom Drilling Company Limited. Counsel argued that this court would be better convinced that Niger Blossom Drilling Company Limited is the employer of the claimant and not the defendant if that document, personnel on board card, is produced by the claimant for evaluation by this court. Now, it is to the knowledge of this court that the claimant was also given a notice to produce the said document via the pleadings of the defendants. The claimant, however, did not produce the said document even after the said notice was served. On this, the defendant's counsel argued and urged this court to apply the presumption of fact provided in Section 167 of the Evidence Act 2011 and hold that the claimant withheld the said document because producing same would be detrimental to the case of the claimant. Now, I have considered the above submissions of the learned counsel to the defendant, and in that regard, it should be emphasized that the law is trite, that by virtue of Section 89A2 of the Evidence Act 2011, that failure to produce a document after due notice to produce is issued only entitles the parties issuing such notice to tender secondary evidence of the document in question. Now, for the avoidance of doubt, I have reproduced the provision of Section 89A2 down. Now, it should be noted also that the presumption in Section 167D of the Evidence Act is not sacrosanct or irrebuttable, as the court may not draw such presumptions if it is unsupported by the weight of other evidence already adduced and admitted in the suit. I shall, for this reason, decline the invitation by counsel to the defendant for the sole reason that Exhibit C1A has, by virtue of its provisions in paragraph 3.4, which is tenure amendment, expressly confine the rights and obligations of the claimant and the defendant within the scope of the said documents, and where it provides that as follows, that the provisions of this offer of employment shall remain inviolable and no extraneous term of condition shall be read into it. End quotation. Now, the above provision is too salient to be ignored by this court. And to this extent, I shall restrict myself to the terms of the contract between the claimant and the defendant, allowing any importation or subtraction to be made thereof, as this is the law. Now, in conclusion on this issue number 3, it is important to state that failure to produce a document without more will not be fatal to the case of a claimant where there is overwhelming evidence to sustain the claims. On the strength of the foregoing, I resolve issue number 3 again in favor of the claimants. Now, at this juncture, the only question that arises is whether the claimant has proven his case on the standard of preponderance of evidence to become entitled to the sole relief sought in the suit. This court easily finds that CW1, when asked under cross-examination about the amounts the defendant owed the claimant, had answered that the amount is contained in the statement of facts of the claimant. Additionally, it is pertinent to note that the defendant never challenged the sum of money claimed by the claimant. Hence, it is presumed that this fact is not an issue of contention whatsoever. By not challenging this fact, it is safe for this court to conclude that same is admitted and needs no further proof thereof. Based, therefore, on the above findings, this court is satisfied that the applicant's case succeeds on the whole. Having thus answered all the questions raised in this complaint in favor of this claimant, I hereby enter judgment and grant the sole relief sought by him. That is all.
As the court pleases.
The court
We are
pleases.
most grateful, my lord.
My lord, we are very grateful.
You're welcome.
Yes, my lord, I have an application to make.
Excuse me, let me thank the court for its erudite judgment.
Go ahead.
Yeah, my lord, I'm very grateful. Thank you for the erudite judgment. Thank you,
Thank you, Mr. Yomai.
Have a blessed day.
You'll get a copy of it immediately after proceedings today.
As court pleases, as court pleases.
Thank you.
Yes, sir.
Yes, my lord.
Yes, please.
We remain very grateful for the judgments. My lord, I have an application to make.
Yes.
Let's move on.
In view of the fact that I have not been appearing in this matter before now, I apply that my name be added in the list of counsel that I did the matter for the claimant. This is in agreement with the consent of the claimant's counsel.
That is Rachel C. in Suffolk.
Rachel C. in Suffolk, my lord.
Ajay Billy CJ.
Yes, yes, my lord.
Right?
Yes, my lord.
Don't worry. Don't mind this copy. Your names will appear.
We are grateful, my lord.
Your names will appear in the final copy. You'll get a copy immediately after proceedings. You can apply to the registrar of the court.
As the court pleases. As the court pleases.
I was only scratching for ground. What would take away?
Okay.
No, not this one. Not this one.
I didn't get you. What's the person at the background?
That's one I took.
I said 13 judgments.
No, I didn't take any chance.
Document
this the
why you know informal see our chance.
Chances. I should tell you, I will tell you our chance.
Yes, next case.
Yes, my lord.
Please, can we be excused?
Yes, please.
Oh, I'm most grateful, sir.
Next case.
Hello, my lord.
Yes.
My lord, this will be all for today, my lord.
Okay.
Yes, my lord.
Right, gentlemen, I wish you all the best.
God.
Simon.
Yes, ma.
Looking at cut, yeah. Simon.
Well, yes, ma.
Buterumu file comrade 150, 160, 2020.
Okay.